colleagues, let us start our round table. It's going to be quite a legal round table, and let's mention the co-organizers. It's a serious organization in the area of digital technologies also. Maybe it's not quite right to speak on behalf of the Chamber of Commerce, but for entrepreneurial activities, these technologies are quite important. The Kaliningrad Chamber of Commerce has been quite active and has become a co-organizer of this roundtable focusing on cross-cutting technologies. And another co-organizer is a digital technology center from the Immanuel Kant Federal University. We will start our roundtable with some welcoming words. Marina Fitzak, Vice President of the Kaliningrad Chamber of Commerce, will say a few welcoming remarks. Thank you. I would like to welcome all the participants. I'm very grateful for these opportunities. Yes, indeed, it's the second time that this event is taking place in Kaliningrad. It's highly important for businesses, the research representatives, and population in general to learn new things, to be aware of what is happening. And the topic of our today's roundtable is very interesting. It's important for us to know where are we going. The creation of technologies and the cultural environment. What national projects are being implemented, what we can offer our businesses. For me, it's important to know what will be the context for local businesses and what will be the role of digital technologies. In some respects, it's of an ambiguous nature, and I look forward to taking part in this very interesting discussion. Thank you very much. We have heard long cooperation with the Institute of Law, and when we deliver training to students, when we coordinate the topics of thesis and diploma works, we've been very close. We are trying to near the research sector and education. And we have something to show other regions as well. And I wish all of you to have a pleasant work.
We are starting our discussion, and I would like to say that questions were raised about questions, when questions should be asked. Maybe in the very end, please keep them in mind and don't hesitate to ask them, because we need your feedback. Because through questions, very interesting things can be revealed. And we would like to demonstrate the experience of our foreign colleagues. We have two foreign guests who will share their experience gladly. It's very important, because when we speak about legislation today, it is developing also with consideration of foreign experience. It can't be ignored. We don't say that it should be copied 100%, but it should be studied, it should be used for the benefit, not through direct copying, but using the relevant experience for the benefit of our country to develop, to help its development. Now I would like to pass the floor to our colleague who will tell us about his experience.
Они сегодня придут?
А ему тоже никак, да?
Придут синхронисты, придут переводчики. Просто чуть-чуть.
Николя, тогда...
Может быть, кто-то может переводить ему, потому что... Может быть, вы сюда сядете и как-то поможете?
Давайте, чтобы так, да.
А перевод идет. Перевод здесь вот в кабинке идет, да. Наушники нужны.
Наушники тогда.
Может быть, Николя попросить, чтобы сказал 10 минут.
Николя, предупредите, что максимум 10 минут.
Предпочитает быть последним.
А он хочет и последним выступать, да?
Последний? Тогда вставляем. У нас, поскольку технические накладки, мы тогда немножко...
We have certain technical difficulties, and we will change the order of speakers. And now, Nicolas, you will have to be the first foreign speaker. Is the first presentation ready? Okay, we are passing the floor to Nicolas Rouiller, Doctor of Law from France. Thank you. I'll try to share a few ideas with you in Russian, and I hope that you will understand me despite my significant, gigantic French accent. I believe that it's impossible to miss this opportunity to make a presentation in Russian in the city of Kant. Maybe it would be of interest for you to discuss what Immanuel Kant, would think about cryptocurrency, because he was thinking a lot about relations between a man and freedom. And it would be interesting to know what he would think about relationship between truth and evidence. I know that we have very little time, and I will not deviate and focus on the topic of my presentation, which you can see in this PowerPoint presentation: cryptocurrency and smart contracts. And these matters with regard to the opinion of a lawmaker.
В принципе, я сам не так долго занимаюсь.
I am involved in cryptocurrency not since very long ago. It exists since 20 years ago. Bitcoins are known maybe for some 10 years. And when it emerged, I thought that I shouldn't be much interested in that. And only after a specific person told me about his excitement about cryptocurrency. It was in January 2014, and he was my very smart client. And it was only then that but I met him in a psychiatric hospital, and then I didn't understand any other value other than buying drugs and weapons for cryptocurrency. And then in Switzerland, we faced the situation when it was impossible to ignore the phenomenon. In 2016. And what happened was a huge mass of initial coin offerings. Maybe it's incorrect to describe it as emissions of future cryptocurrencies. And it was developing really fast. In 2017, for instance, And just one example, it was Interchain Foundation who decided to collect 20 millions and to create the mass of resources that they would collect. They were collecting those 20 millions they were able to collect that over several minutes. Others who wanted to fix the time, say 1 week, but they didn't fix the maximum amount of money. And they were expecting 20 million, but they managed to collect 223 millions. And as a lawyer and as a practical lawyer who work with clients, it was impossible to ignore that phenomenon, because physically it was so that every week there were new projects of emissions emerging on the part of the potential clients who asked us for preparing a legal basis for such emissions. And in response, we started actively dealing with those matters. And for that, we needed to understand what was a priori seemed very abstract, something new. But we understood that at least there were fairly simple aspects. And the first aspect was, unlike one could think, there wasn't the vacuum of law with regard to all aspects of private law. For instance, if we take the basis of matters, what bitcoins and tokens are for payments, and can you pay with that practically with regard to private law? The answer is very simple. If the receiver of the payment agrees, then of course he can get a payment in bitcoins and other tokens. And for that, an agreement is needed. It should be the freedom of agreement which should be applied. And other matters, realistic matters, which one can encounter in the sphere, in a smart contract. What's worth mentioning is that today smart contracts, what they use, those are used in emissions, and they can be applied in other spheres, but so far, in the first place, they are used there. What is a smart contract? It's, again, a very simple thing. It's an agreement, a contract between parties which agree to delegate the execution. They program, they agree in advance that certain events will generate certain consequences. And it is possible to agree about how these will be defined, those consequences. And since several years of working there, I can't see any matters which are totally new with regard to legal rules which should be applied in private law. The basic law is the freedom of contract, can resolve all the matters of private law related to smart contracts. Then in discussion, we can elaborate on that, discuss those aspects in a greater detail. Another aspect that I would like to develop is the question of legal entities which can be used in these fields. It's interesting that it would be possible without any legal entity because the decentralization of the system of cryptocurrency can work without any emittent. It is possible, and this is how it was with Bitcoin. But for instance, with Ethereum, it was totally different. They chose a Swiss legal entity in the form of an institution, and in July 2014. And partially because it was trendy, it was fashionable, because of certain parameters, that legal form was chosen, that particular legal form was chosen. I can mention one cause. Maybe the script is too small, the letters are too small for you to see. Why that legal form was chosen, I believe that that was linked to the fact that the state currencies became relatively virtual. The central bank's behavior, and now I'm talking about serious states, serious countries, without following the rules applied to the European Bank, very solid rules specified in the agreement of creating, in the Treaty of creating the United European Union. The European Bank decided that they can create huge masses of money, of notes, and the Federal Reserve of the United States of America started doing it long ago. The economic theories say that this will result, if they do it, then the inflation will be really huge. They did it while the inflation wasn't obvious. And the virtual nature of state currencies is obvious today. And on the one hand, the virtuality of currencies, and we use that term virtuality for cryptocurrencies, but in cryptocurrencies were just more virtual than state currencies. That was one of the reasons why such a success was achieved from 2014-2015, because the virtuality was similar. That was also the reason why, another reason why it was decided by the participants, the creators, inventors of the new cryptocurrencies, to choose such a legal form of foundation, because simply, if you choose such an institution, what characteristics should be there? A legal entity without a founder. Without an owner. There are no shareholders which can change the statutes. When a founder fixes the objective of the institution, and this mission is fixed more or less forever, and then the board of directors directors cannot ignore this mission. And specifically, if in the objective of the institution, which is an emittent of cryptocurrency, if the statutes say that it's not allowed to increase the mass, the currency, the money, the money mass, then there is no reason to do something different. Then it would be the violation of the statutes. And this is where the big difference with the big central banks lies. I'm not criticizing the central banks that when they increased the mass of money, of course, they have certain social responsibilities. And if people lose their jobs and flats and the economic catastrophe breaks out, then they need to increase the
Учреждение, которое просто эмитировало и должна
monetary mass. Then the emittent of cryptocurrencies, and if in the statutes it's written that the token mass shouldn't be increased, they will not be doing that because there is no reason. For instance, there are no social responsibilities to do the opposite. I'm not going to speak a lot more, just something to say briefly. The activities of a lawmaker. This is what the Swiss lawmakers did in order to attract these cryptocurrencies. Oh, they didn't do anything at all. And it seems to me that it was correct with regard to private law. Very little was done also for other aspects which play a role as administrative law, combating money laundering. I can't say that they didn't do anything at all, but they did very little. And the supervision authorities, financial supervision surveillance authorities explained how they understand the situation. I think it was a very wise approach. And the last field of law, criminal law, shouldn't be changed. I don't think that new crimes should be added in the criminal code.
заниматься этими вопросами.
And if there is fraud, then it's enough. And instruments which exist are enough. I don't want to say that I don't want to say that nothing should be changed in the law. And it's not only about cryptocurrency, it's also about other innovations. Law is usually the last thing to change when innovations are developing years ahead and changes in legislation are lagging behind. And what we can do, what we should do, minimum, is to be very careful dealing with those matters with regard to changing the existing law. Thank you. Thanks for listening.
We have already discussed it with Nicolas, the approach he has just mentioned, that law is not supposed to regulate too much because it's to the detriment of the market. I would like to share a couple of ideas with you because my name is Marina Rozhkova. I am Doctor of Science from Russia. I am a co-speaker as well today, one of the speakers, to continue the topic of cryptocurrencies. We always remember our law on financial assets. dedicated to this issue. When it was started, many of you may remember there was a big debate over that. And Nicola has mentioned it as well, this soap bubble. Many are involved in cryptocurrencies. Many people have heard about blockchain, but it's not so much in discussion right now. So there were some rumor that the government will abolish it. Nothing has changed since then, but blockchain itself is a little bit in a shadow now, and there haven't been any serious changes since then. There will be more technologies, and every time when we have new technologies, people will keep saying that we need to reconstruct the law, need to make major changes. So you may remember telegraph, and there was a book written in 1911. It was about telegraph. If we replace the word telegraph with some modern words, then everything else can apply to our modern life, because new things keep coming. But should we respond in such a way? We often say that law is lagging behind technologies, but why should law be ahead of it? When we say we are lawyers, and when we are talking about regulation, if there are new relationships, so why should we make fantasies? I think it's deeply incorrect to start to regulate anything immediately and very seriously. Why don't we just step aside and look at the topic from a different angle? When we speak about agreement or a smart contract, what novelties does it bring about? If a person would like to deceive a partner in a contract, we can speak about violation of a contract. It's our old tradition, nothing new. When we speak about new technologies, why don't we look at this and why don't we refer to what we have heard before? Maybe it's a new phenomenon which we haven't had before. No, the message is different. Maybe when we have a discussion, some of you will say I'm wrong, but until now I've had this position. My presentation has a complicated subject. Perhaps we should touch upon some significant aspects. Maybe first we should think about automation of law. Some people say it's completely unusual. But when we come to automation or creating algorithms for law, there are many questions. It's been an information that in Argentina they have some artificial intelligence. So, and in Argentina, a judge is supposed to either approve something or disapprove. In 100% of cases, judges were satisfied. But when we speak about such decisions, it concerned a narrow field. It was mainly about some civil or administrative cases, so some compensation to teachers reimbursement of their expenses they have incurred when they were buying some exercise books or whatever. Artificial intelligence. So they made a conclusion that cases like that need to be resolved in that way. I don't think it's unnatural in any way. Recently, it's been mentioned several times that the proportion of judgments of the European Court for Human Rights in most cases were positive. So they can say, they can predict what judgment will be awarded on specific subjects. When we say that artificial intelligence doesn't cope with that and it can offer a draft, then it's the same as a human, as a person can do. I can say that artificial intelligence can be a good helping hand, but we cannot say that artificial intelligence will be a substitute for a judge. It's about fairness and accuracy. Some regulations are very rigid, but judges sometimes take into account some specific points. Well, artificial intelligence is still something different from human beings. We cannot say that as soon as we automate court rulings, it will not be so. Another aspect, when we say that let's code laws and it will be applied automatically. Yes, indeed, we can code, and for artificial intelligence it will be easier to comprehend. Yes, it will be easier for artificial intelligence, but not for humans. So it can be smart from the point of view of technology development, but from the point of view of law, it probably doesn't have any obvious disadvantages, but I cannot say that it has clear advantages either. Another aspect I would like to draw your attention today. Regulation has become more calm and quiet. So we are considering many contractual aspects. A legislator is becoming more careful, and a legislator says, I can give you a chance to find a consensus. And something which is really essential for an industry is taken into account. There was a memorandum when it was stated that today we have no regulation, but we will try to regulate the pirate content. And it was suggested to find a consensus on the anti-pirate memorandum. In any case, the legislator proposed the society to find an agreement on their own. I'm also dealing with the topic called big data. So it's being discussed now that there should be created the code for the code of ethics. when we read reference materials, we see that big data are now placed in the corner. It's not because they're very interesting, but they're very significant. And sometimes when we take big data, they do not always coincide with our normal, usual data. There are many legal aspects about that in many various fields. And in many cases, it doesn't mean that you have to regulate everything, but the code of ethics will help an industry to figure out what needs to be regulated rigidly and what can be regulated on the basis of a common solution, on the basis of a common agreement between the participants. There are many questions, but the legislator tells us, please find an agreement between yourselves. They offer self-regulation. We keep using this term self-regulation, but we need to look into it more deeply to try to understand what really stands behind it. Another thing, I think I still have some time to speak. I would like to draw your attention to the fact that the use of modern digital technologies, we as lawyers, we know how to bypass law, but in some cases, you can use technology and technical means to bypass law. So, but on the other hand, you will not be officially announced as a violator. For example, this law on blocking mirrors. What do we get as a result? When pirate websites are blocked and then mirror websites are blocked, and we come up with an idea that we propose to create those mirrors. So everyone can create his own mirror. No one will find it. These regulatory documents on pirate mirrors, this means those regulations don't need to be complied with. With the help of a technology, you can avoid complying with legal documents. Law should establish some standards, and so that you are not liable for any technical failures. So it's about dissemination of some pirate content. So we don't need any technical means, but we need some economic measures. So I mean these websites which lead to pirate content, those torrents and so on. That's what we call pirate content. The cognition of the society changes, and those which show violence, that's a different thing. When we speak about some areas related to the criminal law, what Nicolas has said before, when blockchain tools are used and when we are trying to combat illegal things, then different standards are applied. I'm talking more about some technical things. The law in the private sector should be more flexible, meeting the sector's requirements and meeting the people's requirements, those people who make use of them. So it's quite obvious today that some legal provisions will continue to be modified. But not always we need this regulation, legal regulation, in the form of a law. In some cases, it should be about some more flexible agreements between content suppliers, content providers. There should be some regulatory documents which are not really legal instruments. So that was my positive conclusion. Thank you.
And now the next speaker is Alisa Belaya. And her presentation will be dedicated to what's on the monitor. I will be brief. The topic is clear. Cross-cutting technologies. This is what I will be talking about. New trends in conditions of transfer of rights. There is a big act called National Project. It's dedicated to digital economy, and one of the elements is a reference to cross-cutting technologies, and it was also mentioned in the national program. Before it was changed for the national projects. Now there are 9 cross-cutting technologies. They are all well known. And when we again talk about those, technicians say that they are known since 1950s, others are known since 1980s. And as a trend we are facing is the application of those technologies and how it can have an impact on our life, also legislative life. This is a big document. On the 21st of February this year, Rosatom, as one of the centers of creating competences, developed an atlas of cross-cutting technologies with 400 pages. I read them all through, and the slide was in the beginning of the atlas. I decided to show it. I counted, there are 9 cross-cutting technologies, and each, as you can see, is divided, and each divided into sub-technologies with elements which can be applied in a greater detail. And today we have 104 cross-cutting technologies which are applied. There is another trend, and it's digital turmoil or digital destabilization of industries, and it touches upon various fields of our life, and we can see those changes. They are implemented consciously or subconsciously in our life. We understand their benefits, and they make our life more convenient. And I agree with the previous speaker saying that it's a pure economic or lawmaking aspect. And what is happening is approximation of not only interdisciplinary within one sector, but intersectoral approximation. And if we speak about regulation, then there are 2 trends. One of them is dehumanization of human turnover, and this is often a trend saying that technologies will replace a human. And there are positive and negative moments in that. And I agree with previous speakers saying that these technologies, to a great extent, may make our life more easy, like all kinds of applications making our life easier of legislators. One of the programs is called State as a Platform, and representatives of science say that those who should approve regulatory acts, they should understand why these are applied and how these will be realized, how these will be implemented. We are talking a lot about digitalization, and very often China is given as a reference when any activity is tracked and has an impact on daily life. A lot is being said about robots and autonomous systems. Marina said that law knows answers to those questions. It's not difficult at all. I like one statement. In the ancient Rome, they managed to cope with that situation. A slave could come and enter an agreement. It was about an object entering a transaction with a subject. Electronic justice system and the role of robots has been mentioned. If these are simple cases, some typical standard cases in the sphere of intellectual property, then maybe it is possible. We shouldn't forget that these machines are analyzing the practice which develops. Then it is possible and no mistakes will be made. And the second trend is quite opposite. And we are talking about human capital during this conference. And here the focus is made on a human being. And one of the threats is being dismantled. Yes, we should understand that changes are taking place, evolution is taking place, but we will not face unemployment among lawyers. In the field of recruiting agencies, Mail.ru has shared the experience that they are rejecting professionals which have interviews and analyze CVs, and thanks to digital solutions achieve the same results. And in healthcare, there is also digitalization used to a certain extent in some typical standard cases and situations. This allows to save time of doctors and gives them more time to get ready for an operation. What I liked also is related to education. People need to educate themselves. They need to learn to study without being scared that robots will come and all the people will go. But we shouldn't let down cross-cutting technologies. Our colleagues were developing a database, and it had to be registered. And we know as a civil code allows voluntary registration of databases. But what's mandatory is the Ross patenting agency registration. And if it is like the qualified electronic signature, who has, if it is a physical entity, a qualified electronic signature? And if you are not a manager, if you're just an ordinary people, and if I print out the papers and sign everything and post those documents, it will be fine. This is not an ideal case either. And in this particular field, the legislation can change and should change. And do we need this kind of regulation? In my opinion, it should be safe regulation to the great extent. I participated in a forum dedicated to law, and colleagues were saying that the only way is self-regulation, and I responded, I disagreed in response. If we this is not the only way. Application of technologies. If parties agree, then why should we interfere? Why should we impose our norm, our regulation? And developing of competences, not only on the professional level, but overall skills are important. Thanks for listening.
Yeah, unexpectedly, we all agree on several aspects. I would like to give the floor to Olga Serova. She will go into more detail regarding human capital. It's the right trend in our discussion. Until now, we've been talking about technologies and not so much about human capital. So, good evening, everyone. My presentation is about cross-cutting technologies and whether they can be used as a social regulator. So unexpectedly, we are in the same pool, in the same camp, who consider there are many various instruments that can withstand many risks. The digital economy, in this context, I can quote the words of Mr. Putin that it's just a way of life. Digital technologies are a way of life. There is a separation of social groups which will benefit from those technologies and digitalization, and who were not so much the beneficiaries of those. The previous speaker has shown the whole range of digital technologies, and some 5 years ago we couldn't imagine in most cases that we would speak about what we are speaking about now. Every time in the past we used to switch to new economic stages, but it's completely different now. I've mentioned on my slides neurotechnologies. What is special today that our ultimate goal will be to use in the economy cross-cutting technologies along with humans, or in some cases it will be a complete substitute. In some cases we can substitute specific activities which can be used for professions requiring relatively low skills. We spoke about judge assistants, about salespersons in retail, and so on. And it's a big question whether the people representing those professions will find a place in the future. So the program has become invalid. The key message there was that the driving force of new technologies should preserve humans against potential risks which new technological solutions bear. Speaking about positive aspects connected with the introduction of new technologies, most of us know them. But on the other hand, they bear some risks in respect of transformation and the pace they are being introduced. And in some cases, we deal with typical legal concepts. Now they find themselves in a digital environment. Very often, we as teachers see that when we deal with our students and we see how they use new gadgets and tools. So most of them cannot imagine life without having them. When we speak about accessibility of education and dissemination of online technologies, it poses certain challenges to our regulators introducing regulatory documents covering the educational and other sectors, which sometimes do not follow the existing trends. Anyway, I would like to draw your attention to one of the consequences. It's being considered in many of our recent researches, that the creativity of humans can be developed by introducing new technologies. And the efforts of the educational sectors are so that humans will be prepared for a stage when your professional skills are not so much in demand, and you should think about finding an alternative place. So there was a definition of human capital given at first in 2013, then 2015, and it was about developing gifts and talents of people. And in addition, there should be some capabilities which need to be further developed in the labor of activities of people. There is another dimension now when your talent will be evaluated as an individual who is prepared for potential risks and novelties. And then we have a question: whom should we train and how? How to interact with the market? So a previous speaker has said that it's not so much related to particular educational requirements, but it's about communicating to representatives of IT clusters and what competences they should carry eventually. It's not only related to professional skills, but so-called soft skills. Most importantly is that an individual should be capable of strategic thinking and apply a systematic approach, worldview, enabling him to adapt to the new environment. In that respect, I can agree to understand the importance of quant technologies. Many representatives believe it has a great potential. It's about people who can explain sophisticated things in simple words. Today, algorithms undertake some functions of humans, and they take decisions, but we should develop an understanding what we are supposed to do about it. No doubt we will get to the point of self-regulation again. It's related to the transfer of legal structures adopted in the social sector, and some old mechanisms cannot operate in the new environment. The future generation, young people, should be able to become intellectual leaders. Maybe we do not understand it right now, but some new sectors and areas will come up, and these people should be capable of predicting the new sectors. And to sum up, I would like to say, referring to the first speaker, that a few years ago, yes, right, cryptocurrency were a big debate, but now, but at that time, nobody knew if how it was going to be regulated. And that's the task of regulators, to think, and professional lawyers, how to regulate those framework. Thank you.
Thank you, Olga. One speaker is left who will tell us about technologies. So the floor is yours.
Thank you so much for the opportunity. Spasibo. That's the only Russian I know here. So I face two handicaps. One is I do not know Russian, and secondly, three excellent speakers have covered a wide range of topics. And for me, the challenge is to see what value addition I can make and I can suggest in this discussion. We're speaking about cross-cutting technologies and the way to regulate human capital. In the city where Immanuel Kant was born, who believed in relationships between humans, the greatest asset of technology is the humans. We speak about blockchain, we speak about artificial intelligence, but I think one thing we forget is it is the ability of the human to adapt to the change in technology that makes him very relevant. Artificial intelligence is nothing but the intelligence of the developer or the coder who is sitting behind the screen and coding and writing his algorithms. Nicolas spoke about cryptocurrency and the way that people are adapting. World over, if you see in Singapore, we have the government and the regulators catching up with technology. So it is not the case of regulatory framework managing human capital, but the human always has a way to catch up with the changes and the cross-cutting technologies that are there today. I'm reminded of a very interesting incident that happened sometime in the 70s. It was when it was the advent of the computer age, the first computers and typewriters. Typewriters was trying to be irrelevant, so you had a lot of stenographers, a lot of typewriters who said that we'd become irrelevant very soon because of computers. So what I'm trying to say is it's nothing to do with the law, but it's more to do with the state of mind. If we feel that we are able to adapt ourselves well to the change in technology, to the change in ecosystem, we will continue to be relevant, because the greatest asset, the greatest contribution that we have made today is that we are striving to be relevant in the new age of technology. And that's the power of the human brain. If you look at Singapore, there are regulations that have come up to legislate cryptocurrencies. Malta is another country where you have cryptocurrency regulations for cryptocurrency. So there is a technical discipline that is being brought about. There is a technical discipline by the legislative framework to monitor these cross-cutting technologies such as blockchain, artificial intelligence. You have the MS5 regulation within the European Union that monitors the same. So it all boils down to the fact that the coexistence of new technology along with the ability to adapt. The human mind is the greatest adapter in modern times. And I'm of the firm opinion that once we coexist with technology, it won't be the case of regulatory framework managing human capital, but it would be a situation or a harmonious situation where you have the human capital and technology dancing in a ballet. Thank you.
Спасибо большое. Мне кажется, можно перейти к вопросам. У нас сегодня, в общем-то, к сожалению, наверное, мы высказались в одном ключе. Если бы, конечно, мы говорили о разном, предлагали разные подходы, было бы интереснее. Но вот как-то так случилось, мы не виноваты. Вот, предлагаю задать вопросы, у кого они есть, мы с удовольствием ответим. Ну, вот здесь прозвучала идея о том, что мы, значит, задали такой ракурс подумать и задать, может быть, нашим слушателям вопросы попозже. Вот поэтому мы с удовольствием ответим на них, если они будут позже, уже в рамках кулуаров, потому что мы тут бываем и, в общем-то, как и вы, присутствуем и слушаем доклады. Поэтому большое спасибо за ваше внимание, мы очень рады вас видеть. Хорошего вечера. Мы ложились во время.
Да, мы уже начали позже, поэтому мы вовремя.